Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt. On the radio, on podcasts, on YouTube, on Facebook, and on talklawradio.com. Today we're going to be talking about a controversial issue that is gender identity and Title IX, and there's a court case that goes along with it. We have a lot to talk about because this is a hidden legal issue blind spot for those of you who are sending your children to college or university and who might be playing in college athletics. So you want to hear about this. You might also be concerned just if you're interested in the way the federal government is regulating universities and colleges and allocating funds to them. This also affects our constitutional rights. So I'll get started. This is a special bonus edition of Talk Law Radio airing on the afternoon on Sunday, and we're going to take a deep dive into the details of a court case that the media isn't talking about. It's called Carroll Independent School District versus Department of Education. So I had to look on the map to see where the school was. It's in Southlake, Texas, and I'm originally from New Mexico, not Old Mexico. That's New Mexico, near El Paso. We actually considered El Paso to be part of New Mexico. And so I'm looking at my map, and Southlake is north of Arlington, and it's sort of right in between Fort Worth and Dallas. And some other towns nearby would be Irving, Capel, Carlton. And so that was just interesting to me to find out where it was. And so this school district doesn't want to have to comply with some new regulations that the Department of Education finalized. They're going to be effective August 1st, 2024. So that's this fall. If you have children attending college or university this fall and that college or university accepts federal funding, then this affects you. So Title IX is the part of the code that prohibits sex-based discrimination in colleges and universities that affect federal funding. And schools that participate in federal student aid programs receive federal funding. So, like I said, this could be a hidden legal issue blind spot if you haven't been following it in the news. Title IX was established in 1972 so that girls and women would have the same opportunity to participate in athletics equally as men and boys at the college and university level. So schools that participate in federal student aid programs receive federal funding, which allows colleges and universities to provide federal financial aid to their students through grants, loans, and work-study funds. So if your school provides federal financial aid to students, it is covered by Title IX. Title IX is the most commonly used name for the landmark federal civil rights law in the United States that was enacted as part of the Education Amendments of 1972. It prohibits sex-based discrimination in any school or any other educational program that receives federal funding from the federal government. The amendments, like I said, are going to be effective this fall in August, and they're regarding the non-discrimination on the basis of sex in education programs or activities receiving federal financial assistance. So Carroll, the independent school district that I was talking about in Southlake, Texas, operates 11 schools for students from pre-K to 12th grade with a student body of approximately 8,400. The new Title IX rule will impact all of the schools and the students. So after the Carroll Independent School District heard about this, they made a resolution denouncing the changes to Title IX. But it's not just Carroll Independent School District that was all up in arms about this. There was Tarrant County Judge Tim O'Hare, who released a statement calling for superintendents and education leaders in Tarrant County to disregard the Title IX amendments. And on April 29th, Texas Governor Greg Abbott sent a letter to the President of the United States stating that the President exceeded his constitutional authority by making the amendments to Title IX. And Governor Abbott instructed the Texas Education Agency to ignore the changes. On May 3rd, 2024, Texas State Representatives Brian Harrison, Tony Tinderholt, Steve Toth, and Nate Schalzlein released a joint statement demanding the Biden administration reconsider the amendments. And then Carroll Independent School District made this resolution. So it says, let it be resolved that Carroll Independent School District Board of Trustees denounces the recent changes to Title IX regulations proposed by the Biden administration, expressing deep concern over the potential negative impact on our students and community, and that the CISD, that's Carroll Independent School District Board of Trustees, urges the Biden administration to reconsider these changes and engage in meaningful dialogue with stakeholders, including educators, administrators, parents, and students, to ensure that any modifications to Title IX uphold the fundamental rights and protections of all students. And the Board of Trustees reaffirms its commitment to maintaining a safe and secure learning environment for all students, free of discrimination, harassment, and violence. So, in their own little way, this little school district is making an impact. Not only did they make this resolution, but they also engaged a law firm to file this lawsuit. The Alliance Defending Freedom organization filed this lawsuit on their behalf. The Alliance Defending Freedom said in a news release, the Biden administration's radical redefinition of sex in Title IX upends our educational system. Carroll Independent School District is right to seek to preserve safety and privacy for the girls and all students under its supervision, said ADF legal counsel Matthew Hoffman. The lawsuit alleges that the new Title IX changes mean that schools will have to allow males who identify as females to enter girls' locker rooms, restrooms, and showers and play on girls' sports teams. Changes are scheduled to take effect August 1st. So I've been reading a lot about this. And I didn't see anywhere in the new regulations where it specifically says that boys who identify as girls can participate on girls' sports teams. But it's thought that the effect of these new regulations will lead to that because of included in the unauthorized discrimination on the basis of sex now includes gender identity. And so if you can't discriminate on basis of gender identity, that means you can't tell a boy that he can't be on the girls' team. So the lawsuit was filed in the United States District Court for the Northern District of Texas in the Fort Worth Division on May 21st, 2024. This was just a few days ago. So this is brand new, and you're hearing it from me, Todd Marquardt, on Talk Law Radio. Tell your friends to tune in and listen to this breaking news edition. So the school district is filing a lawsuit asking the court to stop the Department of Education from enforcing these new regulations. It's called an injunction when you ask the court to stop somebody from doing something. It's also known as enjoining the Department of Education from enforcing their new regulations. Something else that's interesting that I learned while researching this issue is that the National Association of Intercollegiate Athletics, NAIA, voted on April 8th, 2024, to ban transgender women from competing in women's sports affiliated with the organization, effective August 1st, 2024. The NAIA is a major college sports governing body that oversees more than 83,000 athletes at mostly smaller colleges. So what might happen is that the fathers of young girls that are going off to play sports in schools might encourage their daughters to go to these NAIA schools so that they don't have to see boys in the locker room. I was also reminded of the Bible. You might be thinking about this yourself, that in Genesis 1:27 it says, "So God created man in his own image. In the image of God he created him. Male and female he created them." So that doesn't talk anything about gender identity. Okay. If you were alive back in 1972, which I wasn't, you might have noticed that I'm a young man. I wasn't born yet. 1972, the commentators, the original purpose for Title IX was so that girls could participate in college and university athletics, and so that federal funds would be used equally for both sexes. And that's where the anti-discrimination came in, not to discriminate against women and only use the federal funds for men and boys. Here are some of the changes that have been made in the amended regulation is regarding the definition of sex-based harassment, the scope of sex discrimination, including when I talk about recipients, I use air quotes there if you're listening on the radio, that means the universities and colleges that are receiving federal funds. So it's one of the changes, recipients' obligations not to discriminate based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity, and recipients' obligations to provide an educational environment free from discrimination on the basis of sex. So what that regulation is saying is that the universities and colleges are prohibited from discriminating based on sex stereotypes, etc. There's other changes that clarify that sex discrimination includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. The regulations define sex-based harassment as a form of sex discrimination that includes sexual harassment and harassment based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, or gender identity. That is quid pro quo harassment, hostile environment harassment, or one of four specific offenses referenced in the Jeanne Clary Disclosure of Campus Security Policy and Campus Crime Statistics Act. That's the Clary Act, as amended by the Violence Against Women Reauthorization Act of 2013. These regulations would clarify that, except as permitted by certain provisions of Title IX or the regulations, a recipient, that is a college or university, must not carry out any otherwise permissible different treatment or separation on the basis of sex in a way that would cause more than a de minimis harm. De minimis would be Latin for minimal harm. So if it causes more than minimal, then that would be prohibited under these new regulations, including by adopting a policy or engaging in practice that prevents a person from participating in an educational program or activity consistent with their gender identity. So that's what some people are worried about right there, like Carroll Independent School District and the NAIA, is that these new regulations, even though it doesn't specifically say that boys that identify as girls can participate in girls' athletics, but the changes prohibit the universities and colleges from adopting a policy or engaging in a practice that prevents a person from participating in an education program or activity consistent with their gender identity. Something that's interesting about the court case that the plaintiffs pointed out is that it discriminates against different types of boys. Boys that identify as girls are allowed to enter the girls' locker room, but boys that identify as boys are not allowed to enter the locker room. Some other changes are this term LGBTQI+, to refer to people who are lesbian, gay, bisexual, transgender, queer, questioning, asexual, intersex, non-binary, or describe their sex characteristics, sexual orientation, or gender identity in another similar way. The lawsuit that Carroll Independent School District filed also mentions this terminology here is impossible for school districts to comply with because it's not definite. In other similar way could be anything. And so how do you define policies? How do you write policies that guide teachers and coaches and students in ways of behaving or not discriminating if you can't even define what they're not supposed to discriminate against? Here's another statement about how the regulations have changed. In the final rules, or the summary of the rules, the Department of Education said the overarching goal of the proposed regulations was to ensure that no person experiences sex discrimination in educational programs or activities that receive federal financial assistance. The regulations are to prevent harassing a student, including acts of verbal, nonverbal, or physical aggression, intimidation, or hostility based on the student's nonconformity with stereotypical notions of masculinity and femininity or gender identity. Recipients have a responsibility to protect students against sex-based harassment. And so if you compare this type of regulation and policy with what's actually been happening on campuses with students supporting Hamas, harassing Jewish students, well, This is much stricter than what those students who support Hamas have been doing, because it says under this regulation that everyone's prohibited from harassing a student, including acts of verbal, nonverbal, physical aggression, intimidation, or hostility. Well, we can just turn on the TV and see for ourselves that that's what the supporters of Hamas at these universities have been doing against the Jewish students. Another interesting point, misgendering is one form of sex-based harassment. That's what these regulations are going to prohibit people from misgendering these students. That is, referring to them as the wrong gender, that's different from their own point of view. Okay, I talked about misgender. I talked about that really long definition of LGBTQI+. The Department of Education understands the term transgender to refer to a person whose sex assigned at birth differs from their gender identity. The term intersex generally describes people with variations in physical sex characteristics. These variations may involve anatomy, hormones, chromosomes, and other traits that differ from expectations generally associated with male and female bodies. That's where I got the idea to ask God what the definition of male and female was. What I forgot to mention is that the state of Texas has passed laws about this already. In 2001, there was a law to protect girls' sports in Texas public schools that amends Subchapter D, Chapter 33 of the Texas Education Code by adding Section 33.0834 about interscholastic athletic competition based on biological sex. And then more recently, there was a law called Save Women's Sports Act that was passed in 2023. The Save Women's Sports Act protects young women at Texas colleges and universities by prohibiting men from competing on a team or as an individual against them in college sports. Sports have inspired many women to cast bold visions and dreams of what they want to achieve. The legacy of women's sports will be safeguarded for generations to come. And in regards to that 2021 legislation, the governor spoke about some famous women athletes. So this bill, Save Women's Sports, is prohibits, I already said that, a biological male from competing in a college-level athletic competition designated for a biological female athlete to maintain competitive fairness. So what do you think about this issue? Do you think that discriminating against boys who identify as girls is right or wrong? Do you think that girls should be allowed to compete against only biological girls to make it fair? There was an article in the Wall Street Journal, well, it was an opinion article of several students who weighed in on those arguments, and you can find that online. To me, these laws have far-reaching impacts, not just on us today, but for those young women who are just starting out in pre-K soccer, who are just learning to play basketball or softball or baseball, who are just now getting into sports, are they going to be competing against biological males who dress up as girls? Is that a fair competition? Email me at host@talklawradio.com, host@talklawradio.com if you want a copy of that lawsuit. I'm Todd Marquardt. That's it for today. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the Ten Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.